So you've done the work to set up your living trust. You went to an attorney, you had it set up, and you've transferred your real property into the trust. Well, what's next? The question we often get at that point is, well, what about my investment or retirement accounts? My brokerage, my 401k, my IRA. Do those go into my trust? What should I do with them? Hi, I'm attorney Andrew Bethel, and one of the most common questions we get in our office is what to do with our clients' 401ks, IRAs, or just brokerage accounts, their retirements. What happens to those assets, and should they go inside the trust? Now, part of our process is actually going through all of our clients' assets with a fine-tooth comb to determine which ones should go into their revocable living trust and which ones can stay outside. When figuring out which assets should go where, the top line rule we're always worried about is, here in California, the $166,000 rule. And that's the probate threshold here in California. Any assets outside of your trust, add it all together, that equal $166,250 or more, means that your estate would then have to go through probate, which is the whole point of setting up a living trust, is avoiding the probate. So when determining what assets go in or outside the trust, that's that top line concern we're always worried about. So to kind of go through some of the assets I listed, first off is often a brokerage account. A lot of times our clients have an account, for instance, maybe with Morgan Stanley or Vanguard or whoever, and it's just holding a lot of their assets that they've built up over time, a lot of their investment assets. And the question is, should I put that in the trust? Well, we're always worried about that top line rule, so almost every time it's, yeah, that account should go into your trust. We want to put it in that trust and keep it in there because, one, it's typically going to be a fairly large amount, so we're worried about that 166. And two, the idea is, as long as it's being managed correctly, it's going to grow over time. So the ultimate goal is for that number to go way past 166. And because of that, your brokerage account should go inside your trust. But that leaves the other two accounts that I mentioned, and those are typically your retirement assets, your 401k or your IRAs. Oftentimes, your 401k or your IRA, you have the ability to set beneficiaries on those accounts. Now, the act of picking a beneficiary means that the assets in those accounts become the property of that beneficiaries when you pass away. It doesn't count towards that 166 rule. Because of that, we often tell our clients, you know what, if you have individuals that you want to be the beneficiaries of those accounts, it's often just going to be easier to pick live people, to pick those individuals as the beneficiaries of those IRAs or 401ks, and let them go and collect the funds after you pass away. At that point, all they need to do is go to the company with a death certificate and just fill out the right paperwork, and they can have those funds either liquidated and given to them, or they can roll it over into their own investments and gives them a nice big head start on building their own retirement. But the other question we get, well, can I pick the trust as a beneficiary? And you can. Your trust can be your beneficiary of your 401k and your IRA. Now, there are some considerations that you should keep in mind when determining whether or not you should have individuals as the beneficiaries versus the trust. But there are a couple phrases or terms you should kind of keep in mind. It depends on the industry, but you'll hear typically at least one of these three. You'll hear qualified, pass-through, or conduit. Now, our trusts here at our office, by default, are all three of those things. But what does that mean? So what that means is that if there are going to be any taxes owed on assets in, for instance, an IRA or a 401k, then the trust allows for that tax burden to be passed through to the ultimate beneficiaries of the trust. And this is in an instance where you've picked the trust as a beneficiary, meaning the beneficiaries you designate in the trust ultimately receive the funds. So it allows that tax burden to go down to them. Why would you want to do that? Well, the main reason is it's oftentimes more tax advantageous for the individual to pay the owed taxes than it is for a trust to pay any taxes. Trusts are taxed at a much higher rate than individuals. Trust taxes are, well, they just don't have the flexibility that us individuals can partake in when it comes to dealing with our own taxes. Because of that, our trust allows that pass-through of those assets straight down to the beneficiaries, and it also allows those beneficiaries to each pay their individual taxes on their particular section of that inheritance. The other thing to keep in mind is that when you pick your trust as a beneficiary, you can always amend and change your trust during your lifetime, as long as you have a revocable living trust. And that means every time you change the distribution on your trust, you're ultimately changing the distribution on that 401k or the IRA. It allows you to make those changes around the table with your attorney, rather than going through the company holding those accounts and going through their forms. And oftentimes their forms are just more built to have individuals picked as beneficiaries. And sometimes it could be a little bit easier, frankly, for individuals to just be beneficiaries, to go and collect those assets. So when our clients pick their trust as a beneficiary, we often tell them, have the trust as a contingent beneficiary. Essentially, the trust creates a safety net under those assets to grab those assets and distribute out how you have it laid out in your trust in the event that your initial beneficiary or beneficiaries that you listed under the 401k or IRA predecease you. You don't have to go to the company to go and change everything. The idea is the trust steps up into their place, and it's that safety net to then grab those assets and distribute them out how you have it laid out in your trust. One thing to keep in mind with regards to the beneficiaries of your IRA, whether that be through a trust or picking the individual, they do have to take out the full amount in that IRA within 10 years. Previously, they could do so over their lifetime, but under the current rules, here in 2022, they only have 10 years to where they can keep the funds in that IRA. Now they can take funds out over time or just wait until the close of that 10 years. They just can't go past 10 years. Thank you for watching. If you enjoyed the video, be sure to check out some of our other excellent videos here. But don't forget, hit the like button, subscribe, ring the bell, and tell us what you'd like for us to cover down in the comments below.